Hello everyone and welcome to today's Mondac webinar in association with DS Avocats, who will be discussing the most recent development in trade sanctions in France and the EU. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Jean-Marie Sauber is a partner in charge of the international department at DS Avocats in Paris. He puts his expertise in customs law and international trade regulations at the service of the clients of DS Avocats. He provides advice, strategic consulting, optimization, compliance, AEO certification, as well as litigation. Jean-Marie is also registered on the list of arbitrators of the International Chamber of Commerce. He is chairman of the Customs Commission of ICC France and vice chairman of the ICC Customs and Trade Facilitation Committee. Arnaud Fendler works on all aspects of customs and international trade law, areas in which he has developed a strong expertise since 2015. He joined DS Advocates after several experiences in business law in the Brussels office of DS and at Gowling in London. He assists the firm's clients in both advisory and litigation matters in French and English in all the following areas: customs law, economic sanctions and export control of dual-use goods and defence equipment, green taxes, excise duties, trade defence and import VAT. Sophie Dumont-Cap works on all aspects of international trade and customs law. She advises companies on restructuring their international merchandise flows, both in respect of managing customs, indirect taxes, as well as logistical requirements. Her practice focuses on providing assistance with audits and disputes, including advising during the audit itself and on criminal law matters before national and EU courts of justice, in various areas of international trade such as export control, sanctions, trade defence, energy and environmental taxation. Now, before I hand over to the panel to begin today's webinar, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many questions as possible. It's now my pleasure to hand you over to Jean-Marie, Arnaud and Sophie to begin. Thank you.
Thank you very much, Dan. Good morning, good day, good evening, everyone, depending where you are located. We are delighted with my colleagues and partners, Sophie Dumont-Cap and Arnaud Fendler, to share with you our experience on the most recent development in trade sanction in the EU, of course, but with a special focus on France. As mentioned before, we are a business law firm originating in France, but currently locating in 16 countries, with 24 offices and 1,400 lawyers. Our trade and customs team is part of our tax and customs department. We cover almost all matters related to international, indirect and customs taxation. Economic sanction has become a large part of our activity due to the pending international context that we don't need to comment too much. It is the rationale of this webinar today. So we've prepared with Sophie and Arnaud this presentation. I will start with a few global comments on economic sanction, because we think that it's important to understand what is the legal context, what are the challenges resulting from economic sanction. Then we will move to a special focus on Russia and the most recent decision made by the EU regarding Russia. The third part will be handled by Sophie on the circumvention, which is currently a crucial issue and a point of major attention for companies. And we will conclude with Arnaud by the sanction recently, the set of rules related to the sanction. So let's start with a number of notions regarding sanction. Economic sanction, also called restrictive measures, aim to protect the democracy and to fight against terrorism, globally speaking. we have a perfect illustration with the situation between Russia and Ukraine. Usually it results from a decision made by the United Nations, but it can also be an autonomous sanction, which is the case with Russia, because we all know that there is no, so far, sanction adopted by the United Nations. In some cases, local member states can expand the economic sanction adopted by the European Union. The targets are always the same: states, terrorist organization, individual and corporation, and the method as well, globally speaking, financial sanction and embargoes. What is important, and we want to call your attention on that, is the significant increase of economic regime, of economic sanction. Currently, 36 restrictive measures are in force in the EU. And not only this number increase, but the complexity of economic sanction are also growing fast. If we look at our global system in the EU, economic sanctions are related to the Common Foreign and Security Policy, CFSP, which is defined jointly by the European Council and the Parliament. The CFSP is based, of course, on the Treaty of the European Union and Treaty on the Functioning of the European Union, but we don't have time to develop all of these elements. If we look at our system, internal system, it's important to keep in mind that sanction regimes are proposed by the European Commission and then voted by the Council and implemented under the control of the European Commission. Within the European Commission, General Directorate is specially dedicated to economic sanction. It is the so-called DG FISMA, Financial Stability, Financial Services and Capital Markets Union. One of the commissioners is in charge of this DG. It is so far Mairead McGuinness, the Irish commissioner. But of course, we know that this will change shortly because during the next weekend, we will have election at the Parliament. And after those elections, we will have a new commission. So we don't know so far what will be the name of the next commissioner in charge of this point of economic sanction. And last not least comment, the European Commission provides more and more guidance. This is related to my previous comment about complexity. When we speak of complexity, it means that I mean business, need more guidance. This guidance is provided so far, but the FAQ, frequently asked questions, and different guidelines. So an important role also is played by the European Court of Justice. The role of the Court of Justice is to provide ruling on assets freeze and other sanction provision. We have, just to illustrate what we say regarding the importance of economic sanction in the pending context, we had 29 new cases in 2021. And if we compare with the situation last year, 2023, we have 60 new cases. So it's a double of the number of cases, which is a perfect illustration. We don't know so far what will be the number of new cases in 2024, but we already know that we have large case precedents on asset freeze. If we now illustrate the situation and the system in France, which is different, of course, of other member states, we have on this slide two categories of authorities. The first category is the French authorities in charge of the negotiation within the Council. This role is played by the Ministry of Europe and Foreign Affairs, but probably the most important for business, for you companies, is to see who are the authorities in charge of the implementation. And at this stage, we have two agencies which play a very important role. The first one is the so-called DG Trésor. Both of these agencies belong to the Ministry of Economy. The DG Trésor is in charge of the issuance of authorization under the regulation for exception to finance, service and software provision. But an important role also played by the DG Trésor is to issue FAQ, which are complementary to the FAQ provided by the European Commission. Another agency which plays an important role is the so-called SBDU, Service des Biens Double Usage. I'm sure that all of you already know this entity, which issue authorization under the regulation for exception to trade of dual-use, military, high technology and prohibited goods. So this is for the global legal, the global, local and EU framework. If we look now, let's move to, which is the topic of this webinar, what are the most important recent developments in the EU. Of course, there are most of them related to the situation in Russia, and especially with the adoption of the 13th set of sanctions against Russia after 2 years of war. We all keep in mind that this started in February 2022, and this new set of sanctions has been adopted on 23rd of February. One of the illustrations of the growing complexity of this system is, for instance, to see that for the first time, Chinese companies are included in economic sanction and in this very precise 13 set. It limits the trade of EU companies with 3 mainland Chinese companies that have supplied the Russian army. This has to do with circumvention that we will develop later. Also, an important, which is not related to the package, the successive package of sanctions, a very recent initiative has been taken by the European Union, and we call your attention on this new regulation. It has been adopted on May 27, a few days ago, and the EU set up a new country-specific framework for restrictive measures against Russia for human rights violation. You have the reference of this new regulation just to illustrate and to see what it covers, but we will have to see how it will be implemented. It's something similar to the US so-called Magnitsky regulation. But again, we will not develop today too much on that new regulation, just to mention it. Of course, Russia is not the only one. I said before that 36 regime of restrictive measures are in force, and we have this year a new decision made by the EU regarding Iran. On May 14, the Council decided to extend the scope of the sanction regime in view of Iran's military support for armed groups in the Middle East and Red Sea region. We know that this is a very sensitive part of the world, and this is the rationale of this decision made by the EU. Also, a few days ago, on 31st 1st of May, the EU imposed new sanctions for the transfer of drone and missile. Coming back to Russia, where do we stand? We have, as I said before, 13 package of sanctions targeting individual. We see that we have 1,706 natural persons and 419 entities. This is a very unusual long list of persons and entities. You had there the figures, the amazing figures of asset frozen, private asset, and also asset of the Russian central bank. And you have there the different sectors impacted by the embargoes: luxury, high technology, steel, and weapon. This last slide is more to give you the list that you will have this presentation, of course, and this is to illustrate the different regulation and also the guidelines that we and probably you, private sector, use and the different FAQ. Let's move to the second part of this presentation, and we want, concretely speaking, to share with you our practice on the two most recent changes in the economic sanction against Russia. In the last package, we have two new provisions. One is the non-re-export clause, and the other one is the IT embargo. Let's start with the non-re-export clause. This provision is included in the 12th package that has been illustrated most recently. Article 12J of this regulation say that exporters must insert a clause in their contract prohibiting from 20 March 24 this year the re-export to Russia and re-export for use in Russia of different goods that you have there related to goods or fuel additives suitable for space use, weapons, of course, priority goods, firearms, and ammunition. I will give the floor to Arnaud Fender to illustrate concretely with a case, different case studies, the implementation of this non-re-export clause.
Thank you, Jean-Marie, and hi to everyone. So this non-re-export clause is very heavy to handle for companies. Just to specify that this clause is mandatory for all contracts concerning those goods wherever they go, where not only related to exports to Russia. You have, however, two exceptions to this provision. The first one is that this obligation to insert this non-re-export clause in contracts does not concern contracts concluded before the 19th of December 2023. For these contracts, companies have until the 20th of December 2024 to adapt their contracts and comply with the provision. The second exception is contracts concluded with parties established in European Union partner countries. And this list of countries is exhaustive. We have named them on the slide. It is the US, the United Kingdom, Japan, South Korea, Australia, Canada, New Zealand, Norway, and Switzerland. So the exceptions are existing, but we need to make sure that each time it's a case-to-case analysis that exceptions are applicable in one situation. So we share with you in the next few slides concrete cases that we have been handling in the last 3 months. The first one is an example of the contract of supply of items, audio converters, HS code 851762. These goods are listed in Annex 40 of the regulation, so they are the type of goods that need to be subject to the non-re-export clause that we just explained. Our client was a French company selling to Norway, and the contract was signed on the 26th of March. So the contract was after the adoption of the package of sanctions that include that obligation. But because Norway is a partner country, our client didn't have to include the clause in the contract. Now you have a second example of a supply of items to Turkey, to a client in Turkey. There were electrical appliances classified under 853690. Those goods are also targeted by the non-re-export clause provision in the regulation, and Turkey is a non-partner country. The contract was signed on the 2nd of April 2024, so after the implementation of this non-re-export clause provision. Therefore, the contract had to include the non-re-export clause. If the contract does not include this clause, the French company commits an infringement to the EU sanctions provisions. A third case study is a similar one, also Turkey, with computer machines, automatic data processing machines, classified under 857150, which are also a type of goods targeted by the non-re-export clause provisions. In this situation, it was an interesting one because the contract was signed on the 18th of October 2023. So before the implementation of this new obligation, but the situation was difficult because we didn't know whether each export to Turkey was giving rise to a new purchase order. In the situation where the export is made after a new purchase order that is signed consequently to the adoption of the framework agreement, then the French authority and the European authority would consider that each purchase order is a new contract. So if it's a new contract, then you would not be able to benefit from the extended deadline to the 20th of December 2024, to which contracts signed before the 19th of October can benefit. So in our example, it was a contract signed on October 18th, and each export was not giving rise to a new purchase order. It was simply the implementation of one contract signed on the October 18th. So in that case, we considered that this contract could be benefiting from the extended deadline of 20th of December 2024. So our client has another 6 months to adapt his contract with his client and make it compliant with the regulation. So based on these case studies and discussing with the French Direction Générale du Trésor, the authority implementing the sanctions, as Jean-Marie referred to before, we have the following recommendation. The first recommendation is to include this clause systematically in the general terms and conditions of sale whenever the products that are sold are included in the list of products that are covered by this non-re-export clause. It is very important, and it is up to the exporter, to the seller, to provide the evidence that the customer has knowledge of this modification of the terms of sale and has accepted the modification. If you do not want to use the terms and condition of sale option, you can sign an undertaking with your contractors, repeating the terms of the non-re-export clause, and say that this new undertaking will apply systematically to all the contracts signed before and the new contracts coming. If you can show that all parties have signed it and agreed to the content, the Direction Générale du Trésor considered that it is sufficient to comply with the obligation. Of course, this non-re-export clause, regardless of how you're gonna notify it to the contractor, whether it is in the terms of sale or in the undertaking, it must come with adequate remedies to be activated in case of breach of the clause. So saying that your buyer commits to not re-export the goods to Russia is not sufficient. You also need to include a penalty clause or any clause that may allow you to stop the contract or claim damages in case of breach of that commitment. This is very important. It shows the commitment that the seller is expected to implement to comply with these obligations.
Now, thank you, Arnaud. Now we'll have a look at the second important point based on our practice of the most recent changes in economic sanction against Russia is a so-called IT embargo, which targets services and software provided to entities based in Russia. Based on the article that you can see there of the regulation, Article 5, we face a prohibition of direct or indirect is important in this definition, provision of certain types of services, software to the Russian government or legal entities established in Russia. Which means that, concretely speaking, European companies with subsidiaries in Russia can provide those services until June 20, in few days. After, it is forbidden, but, and that is important, there is an exception. If companies are allowed to apply for an authorization to the DG Trésor, and I know that most of you probably are involved in this application process with the DG Trésor, which is based on two conditions. The first one is to establish that this provision of services and software is necessary for the exclusive use of legal person, entities or bodies established in Russia, exclusive use for the group, which means that you cannot provide through those entities of your group those services to other entities based in Russia, such as supplier or clients or partners. Second point is establish that this legal entity is wholly or partly owned or controlled by a European company, so one owned by a European company or controlled by a European company. And I know that a lot of our clients, have questions about this notion of control. To obtain this authorization, you need to follow a process, and we have interesting experience to share with you regarding this mapping. So the most important difficulty based on our experience is to illustrate what categories of services and software are covered. You have there this list, but we can confirm that this list is not always very clear, so you have to go into detail in this mapping in the form of an Excel file. And we had a number of questions, which is on this slide, but I will give the floor again to Arnaud to illustrate quickly those questions, and especially the non-harmonization of the process regarding those authorizations in the EU.
Thank you, Jean-Marie. And just to supplement what's on the screen, the exception works for entities that are owned by European companies as well as groups established in partner countries. So that concerns also US groups, UK groups, Switzerland groups, Japanese groups, and the list of countries that were mentioned before. So the scope is a little wider than what's on the screen. So we have been working on this topic for now the last 2 months. It's true that a lot of French and European groups are getting very active in seeking authorizations to keep providing services, corporate services, and corporate software to their Russian subsidiaries. This is very important. Lots of French groups and European groups remain active with subsidiaries in certain areas that are not as targeted as other areas, sectors in sanctions. So the following questions you have on the screens are just a sample of questions raised by business. You can see they're very, very practical. The first one we had, and several companies asked us this question, is to know whether Microsoft Office 365, the suite, was covered by the list of enterprise software services. It is a recurring question. We also have the question of SaaS as software SaaS provider that license their software to European groups, and these European groups give access to some Russian employees to the software that is hosted on a server in Europe. The question whether this access given to Russian employees is a service that is given, and if it is a service, whether it's the editor or the licensee that needs to obtain the authorization. The way national authorities are dealing with this authorization process is very different. So although we have each European group is subject to the same regulation, meaning that no service or software can be provided to Russian subsidiaries unless authorized. The methods of authorization and the process of authorization is very different from different countries. In Europe, we have on the screen 3 examples: France, Germany, and Italy. France, we deal with it the most, but we also have echoes of what happens in Germany and Italy. So in France, you will have to apply for specific authorization individually. This authorization is going to be valid for 1 year, and you need to provide a certain amount of documents to show that you are established in Russia, that the Russian subsidiary is controlled by a French group. Then you have Germany. Germany has taken a very different approach, has issued a general license. So German groups that have subsidiaries in Russia and providing services and software do not need to ask for a specific authorization. They can just use that general license, which is a much easier process. Just for the knowledge, the European Commission seems to consider that this general license practice is not compliant with the EU sanctions. So we may see in Germany some changes in that. And then you have Italy. Italy has kind of the same approach as France, but the type of documents that is required for obtaining the authorization is different. You need, for example, the Russian subsidiary to sign an end-use statement where he commits to only use the services and software for his own purpose. Sophie, we give the floor to you, and please tell us when to change the slide.
Okay, thank you, Arnaud. Hi, everyone. Yes, so as mentioned in the introduction, circumvention is a crucial matter for the EU because it affects the effectiveness of the sanction regime. So in the recent directive 1226, adopted last April, a definition of circumvention has been given to have a common definition for all the member states. So it is, for example, the use or the transfer to a third party or otherwise disposing of funds or economic resources just to in order to conceal the origin of those fund of or economic measures. It is also the providing false or misleading information to conceal the fact that a designated person, entity, or body is the ultimate owner of or beneficiary of those funds. Next, please. And the next one, please. So thanks. So to illustrate, we such circumvention matter. We recently had an interesting study case within a due diligence from the purchaser side. Of course, we have changed some few information for the presentation. So an EU company manufacture goods that may be qualified as dual-use goods. It means that they could be used for civil or military use. So these goods could be qualified as dual use when they are deemed to aerospace industry, more precisely in category 9. It were kind of molds. So before the EU sanctions, the company used to export to Russia. From mid-22, the company has set up a subsidiary in Turkey where goods are exported, although before there were no exportation to this country. In addition, the shareholding structure has been modified with an intermediate structure located in Dubai, and we assumed that it was a shell company. So based on the above, we said to the purchase company that we could suspect a circumvention scheme. So maybe next one, please. Thank you. So how do the EU investigator identify such circumvention? As you may know, the European Anti-Fraud Office and the various custom administration cooperate to identify such fraudulent scheme. So what is their methodology? So first of all, they screen the variation of export or import statistic to identify a change in the pattern, as they do, for example, in all trade policy investigation. So pieces of evidence can be the variation of quantities, the change of the custom code, the change of the consignee, of the end user, of they check if there are new intermediary traders. They also cross-check transport documents such as bill of lading, CMR, to try to identify potential transshipment. So, next slide, please. Thanks. So, faced with the scale of with the development of very sophisticated scheme, the company has to implement ICP, I mean internal control procedure or programs, to prevent such circumvention, to try to mitigate the risk, to participate or to facilitate to such circumvention. So first of all, the company should map their flow, both financial and physical flow, and they should identify the most sensitive, depending on their business. They should also map the various actors, especially if they are new intermediaries, agents in sensitive areas such as Eurasian countries in Middle East or China. The company should also check the consistency of the information between the purchase order, the banking details, the export declaration, the transport document. They of course they should be sure of they should ask, can I trust this new agent? Can I trust this new client? They should check the various shareholder. They should have, for dual use goods, they should have an end use certificate, because as you may know, for dual use goods, this legislation is based on a triptych. I mean, the goods themselves, the country of destination, and the end user. Okay. Also, they should yes, thank you. This is an example of their end user certificate. And of course, the company should use a non-re-export clause as mentioned before by Jean-Marie and Arnaud. But it is a case-by-case analysis. Arnaud, I'll give you the flow for the next slide.
Thank you, Sophie, and we're coming almost to an end to the presentation. So just to conclude with the status of enforcement in the EU on European section. So you have on the slide a statistics disclosed at the end of April 2024. So you can see some countries have a very intense enforcement policy. Some other countries have a policy that is a bit less intense, but it is growing everywhere. As you can see, France, for example, in April was enforcing very limited actions. But as you will see in the next slide, there has been recently some very important actions of enforcement in France, very intense, and you have now a global policy which within customs authorities to enforce Russian sanctions everywhere. And you also have prosecution offices, so anti-terrorism prosecution office that has charged last week dozens of individuals and companies for circumventing the export of prohibited items to Russia. This is very public. It has been reported in the media, and we also expect more enforcement actions against companies in the next few months. And regarding penalties and enforcement, there has been a directive in April 2024 that was adopted by the EU that aims to criminalize every infringement to sanctions. At the moment in France, it's already criminal. All infringements to sanctions measures are criminal, but this is not the case everywhere in Europe. And with this directive, all infringements to sanctions in the 27 member states are going to become of criminal nature. So this is also going to intensify the enforcement practice and the risk for companies and traders. Jean-Marie, I'll leave it to you at the end.
Yes, as a matter of conclusion, just to see where we are, we expect for the end of June the adoption of the next package, 14 package, and you can teaser, but we don't have time, I guess, to develop the main new features of this new package. Of course, this has to be confirmed. So we are ready for the question, and we will be happy to answer. Thank you. Dan, we give you the floor back.
Thank you very much, Jean-Marie. And before we move to our Q&A section, I would just like to say thank you, Jean-Marie. Thank you, Arnaud and Sophie, for your presentations, for your thoughts and expertise today. We really appreciate it. To our audience, if you do have a question, please do send it in. We have plenty of time to answer those questions. The first question we have is from Andreas. Jean-Marie, Arnaud, you should be able to see those on the right-hand side of your page. Sophie, I'm sure that you've already seen those questions coming in. The first question, is my understanding correct that the 12th sanction package comprises legal services? Is it still possible for employees of European entities to provide legal advice to colleagues employed in Russian entities of the same company group? Can this be achieved by requesting an exemption? Thank you.
Yes, so thank you very much for your question, Andreas. So this is the situation where the 12 package has provided. So until the 20th of June, so in 2 weeks, providing legal services to your colleagues of the same group in Russia is still authorized. But starting from the 20th of June, your employer, so your company, will need an authorization that requesting an authorization to the national competent authority to cover these services and still allow you and your colleagues to provide those services to your Russian colleagues.
Brilliant. Thank you very much for that. We have a couple of questions in that I think are related to those that actually came in beforehand. This question from Stephanie: how can shared IT services for a Russian subsidiary be deemed necessary for prior authorization of Article 5N10?
Sorry, no, okay, we can't see the question on the chat. Can you please repeat it, Dan?
Yes, of course. I've just sent it in. How can shared IT services for a Russian subsidiary be deemed necessary for prior authorization of Article 5N10?
So the situation for IT consulting services is the same as for legal services. You have in the Commission frequently asked questions, you have a detail of what the Commission means by IT consulting services. And this is very wide. And that includes like maintenance of systems, implementation of software or systems. So this is very wide. And as I was saying, the situation is the same as legal services. So until the 20th of June 2024, if those IT consultancy services are provided within your group, this is fine. You do not need any authorization. But if you're going to keep providing those services after the 20th of June, then you need to seek an authorization from a competent authority in the country of establishment of the company that provides the services, the IT consultancy services.
And to complete, we start to have a quite comprehensive list of IT services provided to entities in Russia. Let's say that it's very, very global. Not much IT services are excluded of the list. And we then had a look at the question which is on the screen regarding this IT embargo, if it applies to the US as well. It is an important point that I missed to mention in my introduction. One of the specificities of the European economic sanction is that it is not extraterritorial versus the US economic sanction. So concretely speaking, it does not apply to the US as well from the perspective of the European sanction. But second point, which is important to mention there, is that there is a lot of coordination between the US and the EU regarding the different package. So most of the decisions made in the EU are also made in the US, but again, with no extraterritorial application based on the European sanction, with an extraterritorial application based on the US sanction. I must say that to share with you this practice that we have a lot of questions from our global clients. Usually they raise their question on both economic and US sanction perspective.
Maybe we can add something, Jean-Marie, because the question was, could the US company operating via a new branch could be sanctioned? Of course, if the EU branch has facilitated or has participated actively to a kind of circumvention scheme, yes, the EU branch of the US company could be sanctioned, of course. Okay.
So regarding the branch question, Marius, thank you for your question. The EU sanctions apply to companies established in the EU that have a legal personality and natural persons. So branches, you do not have a legal personality. That's the question you need to answer on your side. If your branch is a legal entity, then it is bound by EU sanctions. If it doesn't have any legal personality, then it's not. But the natural persons working for the branch are bound by the sanctions because they are present in the EU when they operate.
Brilliant. Thank you.
So there is also a question regarding the exclusive use from Elia. What about shared services within the group, which also benefits to the Russian subsidiary as they are for its exclusive use? This is a very good question. So in our practice, and that's how we discuss with the French authorities, and other EU authorities have a similar approach. We need to separate the group instructions from the individual services to the Russian subsidiary. So when you have a group instruction that is given by the head of group to everyone, and it doesn't have a very specific focus on Russia, a lot of people consider these are not services covered by the prohibition of Article 5N of the regulation. But the frontier, the border between group instructions and individual instructions to the Russian subsidiary can be very thin. So it's a very dangerous game. So what we have done in these situations is have a conservative approach. So if it cannot clearly establish that it is a group instruction, then it will go on the other side. It will be an individual instruction to the Russian sub. And then because of the instruction you're given, it can be seen as an exclusive use for the Russian subsidiary, especially if it's a corporate instruction.
Excellent, brilliant. And I just want to check before we move to Dimitri's question that Maria's follow-up question about auditing services, whether they can be conducted by EU entities' employees, was answered.
Yeah, so this is a mix of the answers that we provided before. If these auditing services are part of a group instruction, then they're not covered. But if it's an audit service that is targeted on the Russian figures or like the Russian activity, then it would be a service that would be targeted by the Article 5N. And because it is provided or conducted by an EU person, even this EU person is located outside of the EU when it provides the service or conducts the service, that would require an authorization to cover the activity of that EU person.
Excellent, brilliant. Dimitri asks, do you know what judicial practice exists in case of non-fulfillment of a contract concluded before 2022 by a European company? What decision do European courts make should a European company return an advance received for a product that is currently sanctioned and cannot be delivered?
In European Regulation 833/2014, you've got Article 12 or 11, I can't remember, sorry, that states that any action brought against an EU company that has complied with sanctions, but the fact of complying sanctions harms a third-party partner, any action on that ground will have to be rejected by a court, either in a national court or the European court. So I understand from your question, Dimitri, that the company has to comply because of the European sanctions. The company cannot import the good or deliver the goods that they have manufactured for you or for which you have ordered the manufacturer. So in case of action brought, if this decision not to deliver the good is made in compliance with sanctions in EU, the action may not be followed by any effect.
This also has to do with the so-called force majeure, is the international trade, but in this case, as mentioned by Arnaud, we have a precise information given by the basis EU regulation. Sophie, do you want to add something on this point?
Yes, we had some cases with some arbitration procedures, because for such cases, arbitration can be a more appropriate alternative than a legal action regarding the French jurisdictions.
Thank you.
Excellent, brilliant. So we're coming to the sort of end of the Q&A section, but we do have a question in from Drew, but before I ask for any closing comments. If France wants to make an impact, then why doesn't France use strong or severe sanction instruments?
This relates to our previous comment on the fact that it's an exclusive competence of the European Union. So in some cases, I mentioned in the introduction, France can adopt specific measures not related to European sanction, but France in this case, or any other member state, I mean, has to demonstrate a special prejudice or risk for France. It's not the case in the pending situation, so France is not allowed to adopt more severe or stronger sanction instrument. The instruments are all European, adopted and ruled at the European level, but as we said with Sophie and Arnaud, the implementation is made locally, and this is where we can have a difference of enforcement in the member state. And again, this is what the European Union aim to fight against with the most recent regulation adopted to harmonize the sanction of violation, and especially circumvention mentioned by Sophie in the different member states. But against no instrument can be adopted in this area by France or any other member state.
Yes, we can add something that because in the directive it is mentioned that member state can choose and determine that for some criminal offense the penalties could be 1% of the total worldwide turnover of the legal person. So or it can be an amount corresponding to 8 million euros. For some, it can be until 5% of the total worldwide turnover. So at this stage, we do not know exactly what France will decide, but maybe the goal of course, of the directive is to harmonize. But maybe we would have some slight differences.
Great,
We
thank you.
don't know that. Do we still have time to answer a few questions? So
Absolutely.
the question raised by Elia is very interesting. Arnaud, if you want to, to comment on the group instruction.
So it is. So the question is, can you please come back to the difference you mentioned on the consequences in case of group instruction and individual instruction? So it is very hard to define what is a corporate service. So of course, you have some very obvious examples of a legal service, for example, a legal director negotiating a contract for the Russian subsidiary. This would be like a legal service covered by the sanctions. But we have a lot of group services that are provided on a day-to-day basis that are very hard to define. I'll give you an example to answer your question, because this is a case-by-case basis, but let's try to make a generic example. When you, for example, you are involved in financial consolidation for the group, and for the consolidation of 2024, you're going to send instructions, like the group sends instruction on the way the consolidation is going to happen. This would be a group instruction. So every subsidiary receives the same instructions, like you need to provide your accounts before the end of July or whatever. This is purely theoretical. Once you receive, for example, the consolidation report from the Russian subsidiary, then if there is an issue in the report and there are specific points that you want to see changed, then you're going to give an individual service or an individual instruction to the Russian subsidiary for changing the consolidation report they have made for their own activity. I don't know if this is clear for you. I'm very happy after this webinar to have a call with you to discuss more than that. But once again, this is a case-by-case basis, and it also depends on your own internal organization.
And regarding the previous question raised by Droba, I think that Sophie has already answered with the arbitrability of such a sanction. What is arbitrable, Sophie, I give you the floor, is the the issues among trade partners, not the economic sanction themselves, of course. But in case of difficulties in the implementation of contract agreement, these are arbitrable.
Yes, but maybe Jean-Marie, there is a double question. I mean, because sanctions themselves are not arbitrable. I mean, if an entity is prosecuted by the national authorities, then a settlement can maybe negotiated with the authorities, but they are not arbitrable. But it would be in the if there are specific circumstances to which demonstrate that we can mitigate the offense, but the sanctions are not themselves arbitrable.
Thank you, Sophie. Dan, I think that we are almost, we still have time, but I think we are almost at the end of the webinar. Let me
Unfortunately so.
thank you warmly on behalf of our firm and on behalf of Sophie and Arnaud for this excellent opportunity for us to share with you our practice and also to learn from your question. Its questions are very relevant and very interesting. Thank you very much.
Thank you, Jean-Marie.
Thank you all. Bye.
Thank you, Sophie. Thank you, Arnaud.
Have a
Goodbye,
good day.
everyone.
Goodbye.